Hey, ladies and gentlemen, this is Carmine Sabia for Explain America. And former President Donald Trump, things keep actually getting better for him after the Colorado decision to remove him from the ballot. And legal minds, they're almost in unison on this. Before we get started, please make sure you like, comment, share, and subscribe. You know, guys, there is an election coming up that could decide the future of this country forever. It may be a last chance election, and that's not hyperbole. And when you like, when you share, when you comment, when you subscribe, when you do those things, you elevate our voice, and it needs to be heard now. You guys, again, you're doing a great service by doing that, and we appreciate it so much. So CNN legal analyst Ellie Honig was talking about two different Trump cases during an appearance on CNN. And in this appearance, he explained that the Colorado decision, in his opinion, is going to be overturned by the Supreme Court, that they were trying to fit a square peg into a round hole, and they basically did mental gymnastics to get Section 3 of the 14th Amendment to fit into this case. So I want you to take a look at what he had to say, and then I want your opinions on it in the comments. Of course, I'm Carmine Sabia for Explain America. We love you guys. God bless you. Take care, everybody. And now, let's watch Ellie's take.
Joining us now, former federal prosecutor and Whitewater Independent Counsel Robert Ray, who served as counsel for then President Trump and whose first impeachment trial. Also with us, CNN senior legal analyst and former federal prosecutor Ellie Honig. Great to see you both. Robert, I want to start with you. You were highly critical of the Colorado Supreme Court decision. You point to the fact that Section 3 of the 14th Amendment doesn't specifically mention the presidency. But the follow-up question is, what would be the logic of the amendment's authors prohibiting insurrectionists from holding virtually every job in the government, civil and military, but not the presidency? How would that make sense?
Because the presidency is unique. It is uniquely dealt with in other places in the Constitution. Chief Justice Roberts has already spoken to the question about whether an officer of the United States is limited to just appointed officials as opposed to all officials under our United States government. And the answer is it's limited to appointed officials, generally speaking, unless there's some reason to vary from that, which means that if you want to cover, for example, members of Congress, the Constitution explicitly says so. And if you want to cover the president or the vice president of the United States and other places in the Constitution, you explicitly say so. So, for example, you don't impeach members of Congress. You can only remove them by operation of either the House or the Senate. That was a case that came before the Supreme Court quite a long time ago. And it's generally thought that officers, therefore, should be limited only to appointed officials, not elected officials, because the president's an elected official. Generally speaking, the default position should be that he's not covered by that language. In any event, the Section 3 of the 14th Amendment doesn't explicitly cover the President of the United States. And frankly, I think there's a better reason why the Colorado Supreme Court should have stayed out of this. And that is that the Section 3 of the 14th Amendment is not self-executing. And one of the reasons you get into problems involving, well, what should the standard be in determining whether or not the president is, quote unquote, engaged in insurrection, and what kind of proceeding should that entail? That's all left to Congress. Congress acted in this area in the 1870s, and then ultimately it repealed what was a procedure to determine whether or not somebody had supported insurrection by virtue of being a Confederate. And there was a writ that was required to be issued in order to deal with precisely that question. Alternatively, Congress can pass a criminal law, which it has, to indicate that someone engaged in insurrection can be prosecuted, convicted, and imprisoned. It's notable here that Jack Smith explicitly declined to bring insurrection charges. That should have been a clue to the Colorado Supreme Court to stay out of this. They chose not to. And I think probably what should be recognized is that we all ought to be able to agree that it is not a particularly good look to have judges in a 4-3 decision deciding to keep somebody off of an election ballot. That
All
should
right,
be
so
for the
on that
voters
note,
to decide, not for
what you
judges.
just brought up about Jack Smith not charging the former president with insurrection. Ellie, I want to bring you in on this. The text of the 14th Amendment, Section 3, does not say that someone needs to be convicted of it, merely that they engaged in it. How do you think the Supreme Court may interpret that language?
So I think the Supreme Court is going to take this case, and I think the Supreme Court is going to reverse the Colorado Supreme Court. I halfway agree with Bob. I halfway disagree with Bob. I disagree with him on whether the term an officer of the United States includes the president. There's sort of linguistic exercises you can do either way, but I think it's worth noting all 7 justices didn't have a problem with all officers of the United States, including the president. And also just logically, if you're going to have a provision in the Constitution that says anyone who engages in insurrection can't serve for future office, it would be bizarre if the highest office was
Right,
exempt
that was
from that.
my
I do
question,
agree with
yeah.
Bob, though. Yeah. Oh, I do agree with Bob that we have a serious due process problem here, because the 14th Amendment itself says that Congress, in Section 5, Congress has to pass laws that tell us how this works. Who gets to decide who engaged in insurrection? Is it a court? Is it Congress? Is it a jury? Is it a judge? The only law that's still on the books, as Bob said, that Congress has ever passed is the criminal law, criminalizing insurrection, which specifically says if a person's charged and convicted with this, he's disqualified. That has not happened here. Instead, Colorado tried to sort of take this state-level proceeding that's not really made for this type of insurrection determination and force a square peg into a round hole. And I think that violates Donald Trump's due process rights, and I think the U.S. Supreme Court's going to reverse because of that.